Mr. Mountain, on March 2nd of 2011, are you telling this court that you were at any time in the office of Red Beamer when Miss Georgia Peach actually signed this alleged will?
It is Moutane. Moutane. It's French. Look, I was stuck in a perfectly drab reception area. Red was working on the will with Georgia.
Okay, look, Frenchie, when at any point were you sitting with Miss Peach when she signed this alleged will?
Never, never. I couldn't have fit in the room with all of the people that I didn't know.
So you're telling me there were people in there when the will got signed, allegedly, but you weren't one of them, and you could tell us who they were.
Objection, Your Honor. That's asked and answered.
Overruled.
I do not know who the people are in the room because, again, I was in the reception area.
Your Honor, the plaintiff calls Red Beamer.
Objection, Judge. Really?
Both counsel approach.
Attorney Abel, what are you doing? This is highly inappropriate for you to be calling co-counsel as a witness in this case.
Judge, it's the plaintiff's position that, in fact, this will's a forgery. And the only person alleged to have been present besides Georgia Peach at the signing is, in fact, Red Beamer. She needs to be called as witness, even though she's co-counsel, to refute the testimony of Ruki Montaigne, who says that it, in fact, was signed. But he stands to receive 49% of the estate if it's upheld. Judge, this is the position I'm in.
You must be kidding me, Abel. I have lots of objections for calling Red as a witness. First, she was George's attorney. That means anything regarding the will signing is privileged, at a minimum, work product.
On that basis, your objection's overruled.
Judge, Attorney Abel has not established proper basis for the rebuttal of Mr. Moutaine's testimony. Never mind for Attorney Beamer.
He's lying. Red knows it.
On that basis, I'm going to overrule your objection.
Second, Judge, Attorney Beamer is co-counsel this trial. Attorney Abel cannot call opposing counsel as a witness at trial.
What do you have to say about that, counsel?
Judge, there are no other witnesses I can call to impeach Mr. Moutaine's testimony. Really, what you should be focused on is the fact that Attorney Beamer saw fit to co-counsel in a case where she should have known that she could have been a witness. As a matter of fact, she has a financial interest in how this case is decided, an interest that this, I believe, should be brought to the attention of the jury during my cross-examination of her.
Point well taken, Attorney Abel. The objection's overruled. You go ahead and call the witness.
Are you kidding me? I should ask for a mistrial.
Would you please introduce yourself to the court?
My name is Taylor May.
And what is your profession or occupation?
I'm an attorney at law. I am board certified in wills and probate. I have been practicing law continuously in the state of Florida since 1975.
Your Honor, Attorney Abel and I have stipulated that Taylor May is an expert.
Very well, I'll consider him an expert.
Now, Attorney Taylor May, calling your attention to March 1st, 2011, did you have occasion to meet one Miss Georgia Peach?
Yes, I did meet with Ms. Peach on that date.
Your Honor, may I approach the witness?
Yes, you may.
Objection.
Taylor May, as to Exhibit A, was it made at or near the time of the recorded event?
Yes,
And was Exhibit A completed by or from information transmitted by a person with knowledge who had a business duty to furnish the information?
Yes.
And was Exhibit A kept in the regular course of a business activity?
Yes.
And was it the regular practice of that business to make such a record?
Yes, it is.
I move Exhibit A into evidence.
Objection, lack of foundation.
Attorney Abel, you know that is a non-specific objection, not sufficient to preserve the matter for appeal.
So what, you want me to do all your work for you? Doesn't that kind of take the fun out of it? Hey, I tell you what, maybe I could pen you a letter to your law school, get you some of your tuition back.
Objection sustained. Counsel must establish the witness is a record custodian or the witness has knowledge.
Attorney Taylor May, are you the records custodian of Exhibit A?
I am.
Move Exhibit A into evidence.
Objection, Your Honor. Exhibit A has been altered to delete a handwritten note made by Taylor Made.
No. Exhibit A has been redacted to delete a handwritten note that's inadmissible hearsay. Mr. Dubious, please state your name to the court.
It's Hiram Dubious. I'm the director of the nonprofit Good Hands. Good Hands does good work. It's 98% cost to benefit ratio.
Of course you do good work. I'm showing you plaintiff's, Judge Smith approach. I'm showing you what's been marked as plaintiff's Exhibit A for identification purposes. Do you recognize it?
Yeah, that's an exact copy of the new will of Georgia Peach Mountain that I received on March 1st of 2011.
Your Honor, I move Exhibit B into evidence.
Counsel for respondent?
May I voir dire on this, Your Honor?
Really? Is this really necessary? The witness has already testified that it's an exact copy. I've been stuck with 12 emergency petitions. I don't plan on being here all night.
Very well. If you insist, you may proceed.
Mr. Dubious, is it not true that you were not present when Georgia Peach Mountain signed this document?
Well, I wasn't there in the flesh, okay? I mean, I was present, you know.
So all you did was look at a PDF, a copy.
Yeah, so what?
So you can't actually say who signed this document. You have no idea.
Yes, I can.
And you
I
can't
do.
say where it came from.
Yes,
Your
I-
Honor, objection, chain of custody.
Overruled on that ground.
Wait, what I saw, the old bag signed the new copy of an exact will.
Objection. Lack of foundation, no evidence of authentication.
Attorney, be generous. I'm going to admit Exhibit B into evidence based upon your representation that you're going to authenticate it through your client, Mr. Mountain.
It's Mutane.
What's he doing? Helping on the side?
I got this. Judge, I object to your partiality towards the plaintiff and his client, and I intend to introduce evidence as to the genuineness and lack thereof of Exhibit B without regard to your ruling admitting it into evidence.